Thank you everyone for joining us. We're going to dive right in. Today's webinar is going to be about multifamily syndication, primarily surrounding how whether you should be doing a registration A versus a registration D, and then within those registration Ds, whether you should be doing a 506B or a 506C, and also talking about some of the considerations as to why you would do a 506, B or C or A versus a JV partnership. So we'll be talking about that. We do have a special guest with us today, Jillian Sidoti. Jillian is an attorney, an SEC attorney with crowdfundinglawyers.net. So you can find out some more information about her and her firm at crowdfundinglawyers.net. And before I go into my background and stuff like that, I know a lot of people already know me, but I'd like to be able to recap that for those who don't know, maybe have just joined us. But why don't you give us a background about yourself as well, Jillian, and then we'll dive right in.
So I first started off in this business doing syndications myself. Working for a real estate firm down in San Diego, and we did condo conversions. So we would take apartment buildings, we would buy apartment buildings, bring them down to the studs, remap them, and then sell them off as individual condo units. And it was very lucrative back in 2004, 2005 when we were doing it. And then, the market turned. But before that, I want to be very clear. So when you find this information a little overwhelming, I want you all to understand I was in your position at one point in time. I was syndicating my own deals. I didn't know the law. I was raising money illegally. And I was a lawyer. I was studying for the bar. So you cannot feel bad when you get this wave of information and you go, I don't get it. I don't understand it. It took me law school. It took me being in the business. It took me studying the law, like literally spending an entire year just studying this area of the law before I felt confident to even write an offering. So when you get this information today, I don't want you to feel overwhelmed because I started off right where you are right now, or a lot of you are right now. And after the market turned and we got rid of all the properties, it was kind of like, well, we're not going to do any more condo conversions. The market's plummeting, right? So this was around the beginning of 2007, which is when I went off and started my own law firm and started practicing securities law. So that's where I am today. And what I focus on is specializing in helping real estate entrepreneurs figure out how they're going to raise money for their deals, whether it's through Regulation D or Regulation A. And what the process for that looks like.
Well, Jillian, I want to thank you for joining us, because I know about 3 days ago you didn't even know you were going to be doing this. So I had done a Facebook Live to our group and was just leaving the gym and talking about the webinar that I was thinking about for the week, and you just somehow are coming across it, maybe where you were in a boring meeting or something like that, saw it, but we were able to kind of tune in a little bit and say, hey, well, if you need some examples or want me to help out, I'd be glad to. So glad to have you a part of this webinar.
Me too. I'm very happy to be here.
Great. Well, let me give you a little bit of a background about myself as well before we get started. So I'm the key principal and partner for PassiveInvesting.com. I'm also the owner of 5 specialty medical clinics in South Carolina. We do non-surgical orthopedics. We do a lot of regenerative medicine, sports medicine, that kind of stuff. I also have investments in over $125.3 million worth of multifamily real estate, looking to acquire another $100 million in 2019. And also have a portfolio that consists of a little over 1,300 doors. And as most of you know, I'm the founder of the Multifamily Investor Nation. We have over 3,500 members on our meetup platform, and also we also have our Facebook platform and stuff like that. And it's growing every single day by at least 100 members a week, if not more. And so it's been pretty exciting to kind of see that growth there. And I also am the co-host with my wife of the Tough Decisions for Entrepreneurs podcast. So we actually have 2 podcasts now. We actually just launched one a couple of days ago about multifamily. So the podcast is just Multifamily Investor Nation. So if you just type in Multifamily Investor in your iTunes podcast platform or wherever you find your podcast, you'll find our podcast there called Multifamily Investor Nation. We interview people who have actually closed deals. So we get down to the nitty gritty. We don't just talk about the fluff. We talk about, well, what was the purchase price? How many doors? How'd you find the deal? What was it like working with the sellers and the due diligence and the lenders and the financing and the PPMs and the SEC attorneys and all that kind of stuff. So we talk about all that on that podcast. podcast. It's a longer podcast, but it's weekly. It's a weekly podcast that's about 45 minutes to an hour, diving deep with people who have actually closed deals. So if you've closed a deal in 2018 or even in this 2019 space, you want to be on that, reach out to me. I'd love to have you on there and interview you. But the podcast that I have with my wife is one for entrepreneurs, and it's a daily podcast. So every day we're releasing an episode, and we're interviewing entrepreneurs from around the world that have high level of success, that have faced tough decisions. And we talk about those tough decisions and how they overcame them, whether they were good decisions or bad decisions. We talk about the lessons they learned through each one of them. And you can find that on iTunes as well as other platforms as well. And you can also go to toughdecisions.net to actually find that. So here's a little bit of a picture of my family. I always like to show that because sometimes when we do webinars, we don't really see how real somebody is. And so you can see there on the top right-hand corner, that's me with my wife. In the middle is my 6-year-old son, Caleb. And then you can see my 1-year-old girl, Callie. She just turned 1 2 days ago. So it's a really exciting time right now for us. And my oldest child is right here to the right of me when we're on this splatosphere at the Mall of America in Minneapolis. That's Caroline. And then I have my cute little 2.5-year-old now, Chloe. And yes, she's sitting in her car seat in the back seat of Daddy's car, and she is reading a Jacksonville multifamily market report. So I had just left a broker, and he left it in the car, and she picked it up and started reading it. So maybe she'll be our next multifamily investor in the family. So it's pretty exciting. So let's dive into this, Jillian, because I know, I don't like to spend a lot of time on the fluff stuff. I know sometimes that's important, but, talk to us first, and let me just do this. So I'll explain to you what I understand when it comes to a security, and you can kind of chime in there, maybe give a few extra pieces or tell me I'm completely wrong. How about that? And then we'll have this kind of like dialogue back and forth. So I've done quite a bit of research on it, and I want to make sure that my research is accurate too. So we talk about securities, right? So a lot of times people don't understand when a security is a security. And so we have to first understand at what point is somebody really selling a security when they bring on investors. And what I've always been told is that a security becomes a security when you are selling not necessarily just real estate, but of course in this situation we're talking about real estate, but it could be business or some asset or whatever. But it's when you have something that you're selling where somebody is passively investing money in that deal, and they're basically putting money up for something, but they don't do anything with the business at all or with the actual asset, and they're kind of passive. So I know that might be a bit of a basic description of what a security is, but can you fill in some of the gaps there?
Yeah, as a matter of fact, if you want, let me, I am going to ask you if I can show my screen here.
Sure. Yeah, let me stop my share and you can start yours.
Okay, because, where do I want to show? Right here. I'm going to try this. I'm going to share that, and then I'm going to push this big. Let's see what we got here. So, because I actually have a test here, and I'll show you what the test is. So, the very founding case that gives us the test is actually a real estate test, as a real estate case. So, for example, the W.H. Howie Company, W.J. Howie Company rather, was a farm, and they subdivided the farm into 1-acre parcels and told investors that we're going to sell you an individual parcel of land, and in selling you that parcel of land, we're going to continue farming the land for you, and then as we farm the land for you, we're going to sell the oranges on that land. So they were selling oranges. We're going to sell the oranges on that land and then give you the profits from the sale of those oranges. And so the investors all invested in the deal and bought the oranges or bought the plots of land, expecting the W.J. Howie Company to farm the land for them and sell the oranges. Well, it didn't work out, and everybody lost all of their money. And they sued the W.J. Howie Company on the basis of securities fraud. And the W.J. Howie Company's defense was, no, we sold you a piece of land. You bought a piece of land. Your name is on the title of that land. We didn't sell you a security. And W.J. Howie said, the investor said, no, we bought a security because we expected to get profits from the purchase of this land. This wasn't just us buying a piece of land to build a house on. We weren't going to eat the oranges ourselves. We weren't going to farm the land ourselves. We weren't going to farm the land and try to sell the oranges ourselves. So we expect you to give us our money back, and you didn't tell us we could lose all our money, so you committed securities fraud. And I'm going to actually skip this next slide and go to the next slide. And so the Supreme Court came up with a test based on this real estate case. Here's how you know if you're selling a security. Is there an investment of money? Yes, the people who invested in the plots of land were investing money. Was there more than one of them? Yes, that's what a common enterprise is. In other words, there's more than one investor and all their money is going to the same particular purpose. So they were all supporting this farming operation. Number 3, they all had the expectation of profits. So all the investors expected that they were going to make a return on investment. And that can come in the form of interest on a note, that can come in the form of profits in a deal, that can come in the form of a stated return, whatever it is. It means, are they getting a return on their investment? It doesn't matter how it comes. And then finally, are they passive? Just like you said, are they passive? And if they're passive, then you are selling a security. So if you answer yes to all of these things, then you are selling a security. This is the test you want to use. And that's why I wanted to show this particular screen, because if any of you are screenshotting this is the screen you want to shoot.
So when you're talking about these different items that you're looking at in this test, which we consider the Howey test or the Howey case or whatever, then do they have to meet every single one of those or just one of those?
Every single one of those.
Okay.
And so I know you said we're going to talk about JVs, and I will, in a lot of circumstances, put your JVs right into this test. You will pass the test, and you will be violating securities laws by not doing your JVs appropriately. So keep that in mind for the future of this webinar here. What do
you think is the biggest thing that you see in JVs that doesn't pass this test?
Because they keep going. I'll find these entrepreneurs who go around and keep doing JVs, doing JVs over and over and over again, and their investors are really passive investors. They're not professional investors. They're not participating in the sale of the property or the management of the property, or the management of the construction. They're truly just passive people who are stroking a check and these real estate entrepreneurs think they're being coy by saying, oh, you're my JV partner. Well, no, they're really not a partner. All they're bringing to the table is the money, and you have all the control. And I've seen it happen time and time again, not just with the JVs, but also with the notes. When people sell notes, and they do it over and over and over again, so much so that they catch the attention of a state securities board or the SEC. So one of my favorite sayings in dealing with securities law is, if you have a dog and you call the tail a leg, how many legs does the dog have? 4. Just because you call the tail a leg doesn't make it so. And so when you're saying like, oh, I'm not selling a security, it's just a JV agreement. It's the same thing. So just because you say it's a JV agreement and it's not a security doesn't make it so. That's what I want to be caution all of you about.
Yeah, and for those of you who are listening and might not know what we're talking about as far as JV, that's a joint venture, like a joint venture partner where maybe you and 1 or 2 other investors, and we'll get to that kind of the next question of what's the maximum number of investors you need before you register at the SEC. And I know that it's going to be an interesting answer to that question, and I'm going to answer it first, and I'm going to see if I answered it correctly. But let me ask you this before we move on to that question about these joint ventures where you might have a very small group of investors. What level of participation is the SEC looking for to qualify them as participating in, the actual operation so that they can qualify as a JV versus spending some of the extra money? Because I know that there's definitely an expense to doing the syndication and SEC registration. So some deals, it doesn't make sense to do that. And so you have to kind of make that determination. Is it really worth that going into that deal? Because technically you are selling a security, or is there some sort of role or responsibility that you can give these, for lack of better words, albeit a passive investors, to give them some responsibility to qualify for this test?
So I'll tell you what the answer, well, I want to hear what you say. When do you think, how many investors is critical mass, do you think, to trigger securities laws?
Well, I mean, I've been following you for quite a while, so I'm going to probably answer it the way you probably would. So I would say that no more than 5 investors would probably be the most that you would want to have in any type of joint venture. And so that's what I would say. But obviously, I don't think it really is a question of how many investors it is before you need to register. It's, does your investment fit this test? I mean, does it actually, qualify for being a security or not? And so you could literally have more than 5 investors as long as all of them are participating in it. But I think what happens is once you start to get over 5, it raises the eyebrows of the SEC and the Securities Exchange and the state security commissions, and they start to say, well, wait a minute, you have like 20 investors in here. Are you sure that all 20 are actually doing and participating in this project?
Okay. You're not going to make that argument. So I'll tell you what the law really is, and then I'll tell you what, we kind of do. So the law technically is 2. You have 2 more investors, you've just sold the security, right? So now I don't want that to like make everybody go into a frenzy, like, oh my gosh, I got to spend thousands of dollars now on an attorney to help me with all of this stuff. And I'm breaking the law. So technically, it's 2. What we have internally in this law firm is if you have any more than 5 investors, we suggest you do a full-blown private placement memorandum. So yeah, there is an element of reason here, right? So no, I don't want, if you're dealing with 2 people who are giving you, $50,000 to $100,000 a piece, I do not want to take your money to write you glorious legal documents. I won't take your money to write you glorious legal documents. What I'll do is I'll send you on your way with a tidbit of advice and have you either do it yourself or find a corporate lawyer to write you some good, strong legal documents, but maybe not necessarily securities compliance documents, right? So, and I'm trying to solve, I know that's a massive problem, and I'm currently in the process of trying to solve that problem for a lot of people through some other things, through some software and some online, help things that will help the little guy, if you will, who's trying to do their first deal with, a handful of investors and doesn't have the money for a securities attorney. So, but our internal rule, which I want to make very clear is not a legal rule, is that we require you to have full documentation after 5 investors. So when you have 5 passive investors, that's when we want you to start considering putting together full docs. And what I mean by, 2, if we look back at the rules, investment of money in a common enterprise with the expectation of profits through the efforts of a promoter, that second prong in a common enterprise, we're talking about when you have 2 passive investors. When you have 1 passive investor, you have not quite entered into the realm of securities law yet. You don't do that until you get that second investor, and that's when you cross the line. So, just something to keep in mind. Which leads to the next question. What's your obligation? And your obligation is to disclose all material facts, give them all the details, let them know what the risks are. That's really what your obligation is.
So when you're talking about, somebody who says, let's just say I found a property and I don't have the money and I wanted to bring on one other investor that was completely passive, SEC doesn't care about that. They care if I say, I got 2 people now that I want to passively invest in this.
Right. But I will tell you this, I want to be really clear. I have seen some of the state securities boards go after people with as few as 3 investors, and there's certain states that will like throw a tizzy about anything. As a matter of fact, every single time I have a client who has an investor in the state of Arkansas, even if it's just 1 investor, it's like all hell breaks loose in the state of Arkansas over this one syndication. So, on those lower levels, you really want to be worried about the state securities and less about the SEC. It's when you get into the bigger deals is when you really want to start worrying about the SEC, and you should worry about the SEC. They are a scary, scary organization.
Yeah, and we're going to talk about in a couple of slides here about some examples of some cases of people who have actually gone to jail for not following the proper rules. And, I know somebody had just typed in here about, what's the penalty for not registering, and well, we're going to go over that. We're going to talk about what those penalties could potentially look like. And in the Jailbird Hotel, the Jaybird Hotel, if you will, or the Gray Bar Hotel. That's what I meant to say.
Yeah.
is definitely a penalty that you could possibly be facing depending on the seriousness of it and, how the case goes and stuff. But I do have a couple of questions in here. I know some of them we'll answer in a few minutes, but as I see them, I'll try to answer them if they kind of fall in line with this. So the first question here is from Jamie. He says, if you JV with another investor in another state, it's his understanding if you cross state lines, you are now in SEC laws. So does the SEC encompass everything, whether or not you go into different states and have investors in different states, or is that state specific if you all stay in one state?
You have to follow both the federal law and the state law. I will tell you this, the state law, if you're using what's called a federally covered security law, cannot trump the state law. So no pun intended. But so in other words, and we're going to get into Regulation D versus Regulation A and what that means. But if you're doing a Regulation D under Rule 506, either B or C, or Regulation A, the state is only allowed to regulate that so much. So yes, in essence, you're correct. If you're crossing state lines and you're entering into the realm of securities laws, you want federal rule to apply, and you want to find an exemption under Regulation D specifically. Regulation D is an exemption from registration. I want to be very clear about that. Regulation D is not a registration. It's an exemption from full-blown registration. Regulation A is also an exemption from full-blown registration, but you have to qualify it. I know it's very confusing, but so Regulation A is a qualification. Regulation D is an exemption. You want to make sure you follow the rules under Regulation D so that the exemption applies.
That makes sense. And one question in here is, I think I know the answer to this, but it says, I have 3 investors that are currently partners in a company that was specifically set up to do investing, and that company wants to invest in my project. Is that considered one investor?
Did you put that begets a lot of questions, right? Did you put it together? You have a hand in putting that together. And if you had a hand in putting that together, that's not going to help you. The regulators are very good at following lines, and if you draw lines to yourself, then they're going to.
Because technically that would be one, and if those people were in there not passive, but they were 3 active people participating in that investment company, and they could come in as one person to be one passive investor. But if you were the one that put that entity together to shell 3, 4, 5, or 20 investors into one, they're going to find that. They're going to find that.
Yeah.
They're not stupid.
That's the first thing your investor's going to say. Well, this came from Joe. Joe told me to do it this way. Mm-hmm. I don't know who asked that question. So
yeah. So we're going to go over the differences between that Regulation A and Regulation D here shortly. So I know somebody posted a question about that, so we'll be diving into that here in a minute too. This last question before we move on is, if you have people put their money into a trust account and you are a trustee which uses that account to invest in a real estate project, does that fall into securities area?
Again, I defer to the test. That's why I showed that test straight up front. Is there an investment in money? Is there more than one investor? Do they all expect a return on investment? Are you doing all the work? It doesn't matter. You could put it in. You could put it on the moon for all I care. It doesn't matter. It's a matter of, did you pass the test? If you pass the test, yeah, you're selling security.
Yeah. So let's go to this next question here is can I advertise to people that I don't know? And I think before we answer this question, because I think it'll be in the details of what's the difference between A and B and then the 506B and C. So let's go to the next question, which is going to be, what's the difference between Regulation A and Regulation D?
Okay. So like I said earlier, Regulation A is a qualification. Regulation D is a exemption. Now, I see Daryl's down here asking this question about Reg CF, and I think I have a slide here. If you just give me a second to pull it up, I think I have a slide here that will be incredibly helpful with explaining all of this. Hopefully you guys can read this. All right. I don't know if you want to let me share my slide, Dan.
Yep. You should have that button now.
All righty. Share. I'm going to do this. I'm going to do that. All right. So Daryl's asking about regulation crowdfunding. I'm going to tell you right now, everybody out there, regulation crowdfunding is this one right here. I don't know if you can see my cursor. Hopefully you can. Yep. Regulation crowdfunding is this column right here, this very first one. If you're a real estate entrepreneur, you are not going to use regulation crowdfunding. You're not. Get it out of your head. Don't consider it. It's not going to work for you.
Is there actually a regulation called regulation crowdfunding?
Called Regulation CF. That's how it's written in the law. And so if you look at this whole entire, as a matter of fact, let me go backwards just a little tiny bit here. I don't know if I have a slide that, yes, here we go. If we go here, this isn't a great slide, but let me explain it real quick. If we go here to the timeline, the history of the law, and this is important to understand how we got here. So I don't want to bore everybody with a history lesson, but take a look at right here, 2012. This is when the Jobs Act passed. That was called the crowdfunding law. So that's the Jumpstart Our Business Startups Act, and it made 3 new rules. It made Rule 506C, which we're going to touch on. It made it expanded Regulation A to what it is now, which we're going to touch on as well. And then it also made Regulation CF, which is the quote unquote, the crowdfunding law. So if we fast forward back to where we were on breaking down the law, that's that first column. So Regulation CF, you can raise up to $1 million on a registered crowdfunding portal. And there's only one registered crowdfunding portal that I know of currently that does Regulation CF filings for real estate specifically. It's a website called smallchange.org. So if you want to check that out and you're really interested in doing regulation crowdfunding for your real estate deal, that's the only website that I know of that currently does those types of offerings. Now, here's why I'm going to talk you out of it. The average crowdfunding investor invests, wait for it, $250. So unless you want a bunch of investors who are each investing $250, I don't think regulation crowdfunding is for you. Again, you can only raise $1 million. So if you're looking to do a multifamily purchase, this isn't going to work for you either. Okay, so I'm going to move on. Hopefully, Daryl, I talked you out of that. So what do you do if you're not going to do regulation crowdfunding? Most of you are going to reside right in here in the middle. We're going to do Rule 506B or Rule 506C. So Rule 506B allows us to raise up to as much money as we want through network marketing, through education-based marketing, through our personal networks. We can raise as much money as we want. We can only take up to 35 sophisticated investors and as many accredited investors as we want. I'll get to that in a second. 506C allows us to raise as much money as we want, but we can advertise for investors. We can do what's called, the legal term is general solicitation. This means you can go on Facebook, you can shout from the rooftops, I'm looking for investors. You can do that under 506C. You cannot do that under B. So what's the big but? The big but is you have to verify that those investors are actually accredited. So anybody who invests in you has to be accredited. So I'm going to talk about what that means. The next step up from that is what's called a mini IPO or Regulation A+. This is a qualification, not an exemption. 506B and 506C are under Regulation D and are exemption. If you follow the rules, you don't need to get approval from any state, from the government, from the feds at all. You follow the rules, you go on your merry way. That's how an exemption works. If you want to be able to advertise, take money from anybody, raise up to $50 million, that's when we move into a Regulation A. Now, I'm going to come up for air and let you talk, Dan, to see where you want to take this.
Yeah, sure. So I know there's always some confusion around, not really confusion, but there's questions that come up around if I feel like I can raise all my money from just accredited investors and I can start to attract more investors, can I just go ahead and do a 506C instead of a 506B?
Let me put some statistics out there for you. And by the way, I'm very agnostic as to what you decide to do. I feel like you should do what's right for you and your business. And I have people who come in and go, no, I'm absolutely doing a Rule 506C. And I have other people who come in and go, no, I'm absolutely doing a Rule 506B. The thing I want to lay down for all of you, though, is before you get into the glory of general solicitation, the truth of the matter is people who know you are more likely to invest with you than people who don't know you. So if you think like general solicitation is going to be some magic bullet, you're absolutely incorrect. Number one. Number two, by doing a 506C, you are immediately alienating anybody who's not accredited that's already in your network because they cannot invest with you. It doesn't matter if it's your favorite Aunt Sally who's always, been your cheerleader and always invested with you. If you do a 506C, Aunt Sally cannot invest with you if she is not a verifiable accredited investor. So that's really important to know. With all of that being said, since the Jobs Act passed in 2012 and 506C was made legal, only 7% of all the filings under Regulation D have been under 506C. The other 93% have been under 506B, which means that people are continuing to find ways to raise capital without the use of general solicitation.
So let me give you a kind of obviously there's general solicitation is basically just putting a billboard up, putting a TV ad up, saying, hey, I have this deal. I'm looking for investors for this project. And you can now announce it to the world. If you're in 506B, you don't have that flexibility. So you have to have some sort of pre-existing relationship with them or significant relationship with them. So what are some of the qualifiers in a 506B that would allow you to be able to raise money from, whether it be sophisticated or, those accredited investors?
Like when would you do one or the other? Is that what you mean?
No, I think we've all probably been on Facebook before and seen somebody advertise a deal and we're like, wait a minute. They can't do that, So obviously some people say, well, if you have a closed Facebook group, it's closed, it's not public, then you can. But technically, if those investors have not invested with you in the past, it is not just closed, it's actually public, even though you keep it as a closed group.
So here's the rule. The rule is that you have to have a substantive pre-existing relationship with the investor. It doesn't necessarily mean that they have to have had invested with you before. It means that you have to be intimately aware of their financial ability to invest, which means you have to know that they have, what kind of money they have. And so the way we normally recommend people create this pre-existing relationship, the substantive pre-existing relationship, is that you collect data from that investor through an investor qualification form saying whether or not they're accredited or not, and if they're not accredited, what kind of income or net worth do they actually have. So if you're going to have a closed Facebook page that you want to solicit from, and you only want to do offerings under 506B, how do you do it? Well, before they enter into the closed Facebook page, you got to ask them key questions before admitting them, and they have to answer those questions. That's how I would recommend doing that.
Do you have to actually get on the phone with them and talk to them, or can they just fill out that form and just put them in your database?
You just fill out that form. That's what creates the substantive pre-existing relationship, is intimate knowledge. That's the legal definition. I think you can tell I've said this a couple times. Intimate knowledge of one's financial ability to invest. So if you have that intimate knowledge, whether you've had a conversation with them or not, that's what creates the substantive pre-existing relationship.
Yeah. So I'm not really sure why you would do a 506C other than the general solicitation. And well, let me give you an example from my own self. So I'll kind of be a little bit selfish right now and ask you a question that I've been thinking about, because our group has been deciding on our next deal if we're going to do a 506B or a 506C. So sure. I just came off of doing this 3-day, virtual summit, and we now have a large database of multifamily investors that have opted in, if you will, for our database. And so if they've opted into my database with a 506B, it's my understanding I can't just email it to all those people. I can only email it to people who have gone to my, as you see on my, not my screen right now, but before, passiveinvesting.com, they filled out a form and said, yes, I'm interested in investing.
Right. Now, they said, okay, so I don't want to comment so much on your passiveinvesting.com site without looking at it, but, you know, Dan, do you mind if I use you as an example?
Sure.
Okay, so if you have a massive list, right, and you know that plenty of people on that list are actually accredited, then 506C would work for somebody like you. And I put up here Grant Cardone's website. I don't know if you can see it right now. Yep. He's one of my clients. I did his Regulation A for him. Before I did this Regulation A for him, he was doing 506C offerings because he has a network of accredited investors. And so he would put out, you know, ads for his properties saying, who would like to, oh, my screen froze, who would like to invest with me? And then when it came to time of investment, he could only accept those people who are accredited. So why did we do a Reg A? And I am kind of jumping the gun and jumping ahead here, but he did a Reg A because so many people who said to him, I want to invest, were not actually accredited, and so he could not take their money. So he did a Reg A so he could take those unaccredited investors. For someone like you, Dan, if you have a big list, even if it's not as big as Grant Cardone's, but you know that a good healthy number of those people on there are accredited, then it would make sense for you to do a 506C offering. And what I tell people is that unless you have like some kind of you know, mass networking or some kind of list that you've put together, 506C doesn't make sense for you because else you're going to just be, you know, spending money on Google AdWords and Facebook ads. That going on, you know, Multifamily Investor Nation, for example, and saying, hey, everyone, I have a deal. I'm offering 8% preferred return without being a trusted source. It's not going to do you any good. No one cares. People are going to just pass on by. They're going to think you're either soliciting illegally or super desperate. So.
Well, and that's kind of what we had thought about too, is because, you know, just to be, you know, I like to be as open and direct as possible. So I'm glad you used me as an example. You know, we have an email list now that we've been developing of, you know, and this is a fresh email list. We have over 6,000 people that are in this email list. And I would probably venture to guess between about 5 to 10% of them are probably accredited. Maybe more than that. I don't know. But, you know, even at, you know, 5%, that's 300 accredited investors that you can promote a project to. Right.
I mean, that's a pretty good chunk of change. So, you know, I also say, you know, take a look at like websites like CrowdStreet and sign up for their mailing list. See the kind of the email you get from them and why it's appealing, why people invest with them, et cetera, et cetera. Take a look at those types of things for sure.
Yeah. Well, and I think the biggest thing for me is I want to make sure that people who maybe didn't even know that they could invest with us, they could, but I don't want to get into some securities issues or securities, you know, problems either. Let's talk about Regulation A as well, because I've been considering doing a Regulation A, but I have a lot of questions surrounding it. And so I know that Regulation A is the kind of the larger piece of it, and there's two different tiers. The first tier is up to 20 million. The second tier is up to 50 million. Obviously, right. With those different tiers, there's different questions that you have to be able to answer and stuff like that, or different qualifications. But what are some of those you know, nuances as to why you would do a Regulation A and try to get a $50 million fund or something like that?
Okay, so for right now, what I have up on my screen, I just want to verify that this is what you're seeing, is I have the 3 different types of investors that there are out there. Our highest investor is an accredited investor. That's who we've been talking about for 506C. So if you're doing a 506C, you can only take accredited investors. Those are people who make $200,000 a year as an individual, $300,000 a year as a married couple, or have $1 million net worth exclusive of the primary residence. So that's our highest investor. That also, depending on what statistics you look at, is only 3 to 10% of the American population. So, but that's still a good chunk of people, right? It's about 9 to 30 million people. Then our second type of investor is hard to quantify because it changes with education and time and all those other things. So our second type of investor is a sophisticated investor. It's a subjective test. A sophisticated investor is someone who doesn't have the income or net worth of an accredited investor, but has the knowledge or the experience to understand the risks associated with investing. It's a subjective test. For example, I might be sophisticated enough to invest in real estate, but not sophisticated enough to invest in Bitcoin. That kind of thing, like, because I don't know enough about Bitcoin, or I'm just throwing examples out there.
Sure.
Our third type of investor is an unaccredited investor. They may be sophisticated, they may not be sophisticated, but that's everybody else. That's anybody who does not make $200,000 a year, $300,000 a year, or have a net worth of $1 million. Now, why this is important? Because as we saw, this matters for our types of investment. Under B and C, under B, we can only take sophisticated and accredited investors. We can't do any general solicitation, so no advertising for investors. Under C, we can generally solicit, but then we're stuck with our number one investor, accredited investors only, which is 3 to 10% of the population. Under A, we can raise up to $50 million, and we can take money from anybody using general solicitation. So if we go back to that Cardone Capital thing that I had up there, we see that he has a Regulation A over here. So anybody who wants, and I'm not promoting, I want to be very clear, I don't promote any of my clients to invest in any of them. So you have to make your own decisions regarding that, and you got to read the offering documents. And just using him as an example, or this website as an example, because we can see the juxtaposition of 506C and Regulation A. So here, now Mr. Cardone can take any investor in his deals. What did he have to do to get this done? He had to get approval from the SEC. So we had to send in a document to the Securities Exchange Commission that said, here's what we want to do. Please approve the Securities Exchange Commission. Wait a period of time, and now he can go out and take money from any investor off the internet. He doesn't have to know them. He doesn't have to have a pre-existing relationship. They can make, no one can invest more than 10% of their net worth or net income, whichever is greater, but they don't, he doesn't have to have that significant relationship with them, and practically anybody can invest.
Okay. So what is that approval process like? Like, how long does that take?
It depends. I tell everybody to plan 4 to 6 months though, because there is a back and forth comment period. So let me pull up over here. This is the SEC's Edgar system, and so what you see here is we sent this in July. They basically turned Mr. Cardone upside down and shook him out several times. So these are all our iterations of the same document based on things the SEC wanted us to change, or they saw, or they didn't like. And then what we ended up doing when he finally got qualified, this is what it is, his qualification letter right here. When he got his qualification letter, we filed what's called an offering circular, a final offering circular. This is the final thing that the SEC has approved. They said, yes, you can go out and present this to investors. And so this is the business plan. This is the business plan. This is telling the investor what is going to happen when they invest with Cardone Capital or Cardone Equity Fund 5. That's what this is called.
So when you're doing this approval process planning, 4 to 6 months, obviously, Grant Cardone might have a little bit more for them to be going through. So I saw in there the first filing was like January of 2018. And at least I think that's what I saw in the beginning.
No, this one was July. So this one was July 3rd, and we got approval in December.
Oh, that's the January 17th, 2019. Okay.
Yeah.
All right. So that was done in July.
That was recent filing. I think this was him acquiring No, this was them firing the auditor. Oops.
Oh, okay. All right. So, okay.
Yeah.
Well, that's typical, I think, for him to fire people, which is good. Which is fine. You know, I probably would fire him too. Who knows?
Yeah.
You don't
No,
know the situation. You don't ever know the situation. So
no,
in
and
this situation
these are
takes.
just reports. These are just reports saying here's what's going on. So this is called a 1U. We have to do this every time something big happens. So in this 1U here, which was filed in January 11th, we were reporting that they had purchased a property on behalf of the fund.
Okay, so whenever a property is purchased, that would be in there as you know, documentation to kind of
Right.
for the SEC to continue to track it. What are they looking for? The regulate the SEC, are they just trying to make sure this person isn't a fraudulent person? Are they looking for experience? You know, what are they looking for?
They don't care about your experience, believe it or not. Let me see. I'm going to pull up this. And by the way, if you ever want to do this, I'm going to give this to you in real life time. If you ever want to look up a company, if you want to ever see if somebody's being compliant, this is where you do it. Because even under Regulation D, we still have to file something. We have to file something called a Form D to show that that a company is using the exemption and using it properly. So for example, if you ever want to find out if a company's filed their Form D, you can just go to company filings and type the company name in. And so I'm just going to type in one of my clients that I know has a Form D filed. And you click on it and it will come up right there. It'll tell you what they filed. You can read the Form D itself. And it's a pretty simple form that the client signs and says, here's the exemption we're using, here's our information, here's how much money we're raising, all that other good stuff. So it's very, very simple, very, very straightforward, but it is very, very necessary to file in order to be compliant under Regulation D. But you asked about Regulation A, and so I want to bring up one of my clients. What is their name? Why am I drawing a blank? Sorry, I'm going to move over to this guy over here. This is Tulsa. This one right here is Tulsa Real Estate Fund. Tulsa Real Estate Fund is a company in Georgia. This took a very, very long time to do. This is for all intents and purposes a single family flipping fund of sorts. Actually, that's not really totally true. They're not an anti-gentrification fund. They didn't care about the experience of my guy. They cared more about what he was going to do with the investors' money. That's really what it comes down to. And it's not really even that. It's more like, are you telling us completely and utterly what you're going to do with the investors' money? And are you completely and utterly telling the investor all the risks associated with that? So that's really what it comes down to at the end of the day. They don't care about your experience whatsoever, really. I have this guy right here. I want to show you something really quick. This is my client, Keystone Investors. They buy apartment buildings here in Southern California. And if we go down to control persons, I'd like you to take a look at this. Can you see? I hope you can see that okay. Zoom in a little bit. Oops, I went too far. But if you look, Austin Nisley, age 26. I got this offering through in 2 months. So your level of experience is not really important. It's about, are you going to be a good steward of your investors' money?
Yeah. Well, that's very interesting because I'll talk to you offline about a few ideas that I have because I don't want to give away all my secrets, on the webinars. But stay tuned for my next Regulation A coming out.
Oh, yay!
Yeah, no, I mean, I think that's one of the things we've been considering doing, and one of the things that. Let me ask you this. So I'll give away my secret sauce. Okay, here we go. So here's my question to you, because I think it would be helpful for people to kind of hear what we're doing too, or what we're thinking about doing. Is a lot of people come to us and specifically ask, can you help us raise money for your deal? And we turn away about 90 to 95% of the people who come to us that want to raise for them, because they just don't fit certain qualifications that we put into place. And so we're very strict on who we actually raise money for. But one of the things that we would like to be able to do is to have maybe a Regulation A fund that actually does the funding on some of these projects that we want to be able to participate in, instead of having to go through the whole webinar and conference call and stuff like that. Just have a fund set aside that we invest in other syndicators' projects that fit our qualifications and our criteria. So would that be a good situation where you would want an actual Regulation A for?
Yeah, you can do that. Now you have to have some, I have written Reg A's like that before, so that can happen. You got to be very careful with that though, because you want to make sure that you are still investing in real estate. I don't want to get into the weeds, so we might want to talk about it offline a little bit. But there's other laws that will get triggered if you don't do it just so, and we don't want to trigger those other laws. Is basically what I'm coming down to. You don't want to be an investment advisor, is what I'm trying to say. You want to be able to go in and invest in another syndication, but you have to have some kind of modicum or element of control over the syndication in which you invest, lest you be deemed an investment company and you don't qualify for the exemption under 3C5 on the Investment Company Act of 1940. So that was a really long way of me saying, yes, you can do it. We just have to make sure we follow certain steps. So
you'd have to basically have a seat at the GP table or have some ability.
Yeah, a little bit. And there's all kinds of different ways to do it. So, but we can do it.
Okay. Well, that's interesting. Well, that's definitely an idea that I had. And I know you guys have a couple other questions here, and I want to share my screen again here with you guys to kind of go over something else that I wanted to cover, which is somebody asked earlier about, what are some of the penalties that can go into place when it comes to not following these guidelines? It's not all about just trying to, keep Jillian busy with work. She also wants to make sure she helps keep people like us out of jail, so we don't have that type of an issue too, which is why she's there. And she sounds so passionate about what she's doing. So first off, let me share a different screen, because you have the slide up there right now. But let me share with you, where did it go? New share. There it is. All right. So let me pull up this screen here, and you should be seeing my browser. Is that what you see right now?
Yes.
Okay. You should see your website's up right now.
Yep. Thank you.
Okay. So this is her website. So if you guys have a lot of questions, there's a lot of questions that you guys still might have, and we're done here. This is where you can go to find some additional answers and some of your questions, and reaching out to Jillian. It's just crowdfundinglawyers.net. But here's an example. Oh, wrong one. Here's an example of a gentleman, which is called, this is the title. This is Owners of Bay Area Equity Group Charged with $3.5 million in fraud. And they were, basically, they turned out to be, pitching people that they were investing their money in these homes up in Detroit, and ended up there were no homes that they were investing in, and they were now indicted by, obviously this is a lot more egregious than just, not registering, but the reason why we right. Well, and I think that the biggest, thing too is that for those of you who are listening who are passively investing in other projects or doing JV partnerships, you need to make sure that you know that person. The reason why these laws are in place are not just to make our life difficult; they're actually to protect us. As much as we don't think that sometimes, they're there to protect us. So when you think about why they created these laws and these rules, it's because of a lot of these Ponzi schemes that have been out there in the past, and that still, are out there today. So before you start, putting money into a project, you need to verify who these sponsors are, who are the people who are leading the deal, and are these deals actually registered? And then, making sure that you see maybe what are some of the other deals you've done in the past. Go verify with that Edgar system at the SEC and see, are they actually filing the proper forms, and are they actually being up and up about this? So that's one of the biggest things I would say about this. And the other one here I would bring up is this Leighton man pleads guilty to $3.4 million in Ponzi scheme as well. And so there's this guy's in jail, right? Like, there's a lot of things that happen that you don't want to get involved with, and you might look at this and go, yeah, well, that's not going to be me. Well, you never know, and so to be safe, why don't you just go ahead and call Jillian and make sure you get registered properly and do things the right way. And these two examples I actually got from Kathy Fetke. She was on the summit last week when we had the 3-day Multifamily Investor Nation Summit. She shared these 3 cases, so I thought it would be good to be able to show these to the audience today. So you can kind of see that, yes, there can be some consequences to this as well.
Oh, for sure. Oh.
Let me go back to the PowerPoint slide here again and go over. Let's see this. So you have a crowdfunding workshop that you're doing on February 7th and 8th. So why don't you share with us a little bit about what's going to be happening at this event?
Oh yeah, I would love for any of you that can come out to come out. I'd be so honored. It's in Orlando, obviously. You can go sign up at our website, crowdfundinglawyers.net. It's a really small group. We do this on purpose, where we have these really small groups. As a matter of fact, we sold out of our last one. And we sold out at, I think we actually had more people than we wanted. We had 40 people. We really only wanted 30. So we oversold the room. It was kind of uncomfortable. So we're not doing that this time. We do still have seats available. So if you want to come, crowdfundinglawyers.net, you can come and learn how to market your deals, learn all the laws, learn how to put together legal documents, learn what's in those legal documents. If you're interested in doing an opportunity zone fund, we'll teach you all about that. We'll teach you the differences between Reg D, Reg A, crowdfunding. We'll lead you towards the crowdfunding platforms that can help you with raising capital. And we'll also lead you towards the type of marketing you should be doing if you're going to stick with 506B and how to do that.
So I know we're right up against the 2:00 hour on the Eastern side. Do you have a few more minutes to answer a few more of these questions, or do you have to leave?
Do it.
All right, cool. So let's go to these questions right now. So the first question that came in when we first jumped on was, if you have friends or family interested in investing but are not accredited or sophisticated investors, can they be part of the money raise or investment either as passive investors or possibly as a hard money lender?
Okay, you've got to be really careful with people who are not accredited, even if they're friends or family. And the story I always like to tell is, many years ago, one of my very best friends asked me, can you find me a real estate deal to invest in? And my response to her was, why don't you go to a RIA meeting and get some education first? And she told me she was not interested in going to a RIA meeting. She was interested in investing in a deal, just to find her a deal. So I did. I found her a great deal with a friend of mine that I thought, okay, this is a good friend of mine. The friend will treat her very well. It's a good deal. It has a lot of margin in it. It was a sexy deal. And what I mean by that, it was a house overlooking the ocean in Santa Barbara. It was a single family flip in Santa Barbara, California, which is a really posh location. So I thought, okay, this is a sexy deal. So I brought it to her, showed her the numbers. It had, like I said, huge margins in it. And her question to me was, is it guaranteed? And I said, not for you. Not for you or anybody else. And her asking me that question showed me she was not ready to invest. It just showed me she did not understand what it means to invest or how to invest and what the risks are associated with investing. So I hear what you're saying about having friends and family that are not sophisticated or accredited and being nervous about taking, or not being nervous about taking their money, but still wanting to take their money, but not knowing how to do it. And my response to you is educate. The best marketing you can do, not just for your investors, but for your business, is to educate your investors before they invest with you. So get those investors to be sophisticated. Get them to take classes. Tell them, look, I would love to take your money, but you need to know what you're getting into first. And I know that's a really painful and hard thing to do when somebody's ready and willing to invest with you. But under 506B, those investors have to be sophisticated. And I'm telling you, it protects you just as much as it protects them.
Now, from a hard money lender standpoint, that could possibly be an option for them, but they'd have to be in the debt side, not the equity, right?
It has to be in the debt side. And let me explain something about those rules about, deeds of trust and mortgages. They're very, very specific. Though there is no federal debt like note law. that says, oh, if you take a deed of trust or mortgage, then it's exempt from securities law. There is no federal law like that. That is state-based. So what do the state laws say? They're very specific. They say you can take an investor in, it would be exempt from securities law if you secure a note with a deed of trust or mortgage, number one, so it has to be secured. Number two, you cannot advertise for investors. So the general solicitation rules still stand. You cannot advertise for investors for that deed of trust or mortgage. And number three, and this is really key, that deed of trust or mortgage, or that note that is secured by the deed of trust or mortgage cannot be fractionalized. So you can only have one investor per deal or per deed of trust or mortgage, per note. So if you know you need $150,000 and your investor only has $100,000 and that's not going to cut it, that law, that exemption is not going to help you.
So another question that came in here was from Anna. She said, I work with SEC regulations related to hedge funds within insurance policies and know we can't produce quote unquote advertising materials in that realm. When it comes to real estate, what level of materials can we provide for review to prospective investors before they see an OM or fact sheet if this is a 506B offering?
Yeah, I mean, the follow-up question to that, which is, do we have to use a certain investor questionnaire before showing any details of the deal if we know the investor but not all of their financials? You know, I always say proceed with reason on this one, which is that if you're, you know this guy has money and is interested and blah, 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 and you've known him for a while, then no, I don't think you have to flash an investor qualification form in front of him before you talk about the deal with him. But, you know, it is always wise to get that investor qualification form on file. Like if you have a pitch deck that you're wanting to provide to investors on a one-on-one situation, that is not general solicitation. So I say, just proceed with caution. Obviously, you're not going to take their money until you verify what their qualifications are. And on that marketing material, if you will, it should say that no offers are made except through the offering material, so the private placement memorandum. So that's kind of how you get out of that one. It's hard for me to answer that question with more specificity without seeing the materials, right? So we're saying, I have these generic materials that don't exist and you can't look at. How do I use them? I can't really give you a really specific question. So those are some guidelines for you right there.
So the next thing here is with a 506B multifamily raise where someone's a GP, are non-citizens considered the same as U.S. citizens, and meaning that you still have to have those 2+ or significant relationship with them before you actually provide them with a PPM?
So no, foreign investors are treated under Regulation S. There will be some legal minds that will tell you that even foreign investors under 506C need to still be accredited. I don't know if I necessarily agree with that. So the short answer is no, because foreign investors are under Regulation S. The long answer is what we do with foreign investors is we provide them the same disclosure as if they were living in the United States. And the reason for that is because an investor can still sue you for fraud for not disclosing all the material facts to them, regardless of whether you violate securities laws or not. So that's kind of how we handle that.
Okay. Next one is about, I'm not really sure the best way to answer this, but can we talk about the investment project in the real estate clubs and IRA meetings?
I don't know what that means. And I say that with all due respect. I get that question all the time. I don't know what you mean when you say that. Are you getting up in front of a room and saying, hey, everybody, I'm offering 8% preferred return? Or are you getting up in front of the room and saying, I'm really excited about my Houston deal. I just wanted to share it with all of you. It's 277 units and it's a Class B building in a Class A area. I think I can really add some value to it. So anyhow, that's all I wanted to share with you. Have a great night. Like, yeah, that's fine. You're just talking about your business. If you go up and end that with, if you're interested in investing with me, come see me later, that's a general solicitation.
Yeah, I think that's what he just typed in here. Matthew just said this is for the raising money.
You can't be raising money in front of a group full of people that you don't have a pre-existing relationship with unless you're doing it under 506C and only accepting accredited investors at the point of investment, or you have a Regulation A offering.
So final question here, which is a question that I'm going to be probably asking you too, is what's the average cost to do a Regulation A filing?
The average cost versus what I tell you to put aside are two different things. We suggest you have $75,000 put aside to get you through the first year. The average cost, I don't quite remember. It's in the ballpark of like $250,000. We try to be lean and mean for you and make it very affordable. That $75,000 doesn't go all to me. That's for a bunch of different things that you have to pay for. But what we suggest is that you have at least $75,000 stowed away for the purposes of getting you through the first year.
And so the actual first year before you actually get approved and stuff?
No, the first year of getting approved and getting your ongoing reporting requirements. If you remember, I showed you a couple of little reports that came up that you need to continue paying an auditor. We put our fee for the first year of reporting in the fee for the registration, so you don't pay any extra to the attorney. That's one of the perks of working with us. But we do want you to have at least a little bit of a slush fund for other little expenses that are going to come up in that first year.
So when you start to raise for this fund, let's say I called you up today and I said, hey, Jillian, I want to get this started. It's now almost February. So we're talking about February, March, April, May, June, possibly July. You know, I could have the actual offerings available, the fund available, if you will.
Right.
That's 6 months down the road. And when I go ahead and now file the proper filings and now have the ability to talk to investors about it, getting the approval, I'm now talking to investors. I'm starting to fund my fund. At what point can I start to fund properties and projects? Do I have to wait till I get the full 20 million in the tier 1 or the 50 million in the tier 2, or can I do it and only have a $50 million fund, but only raise 20 million and only invest 20 million?
You first and foremost, you're never going to do a tier 1. I don't let anybody do a tier 1. They're a massive waste of time and money. So you're only going to do a tier 2, and we don't have enough time to go into why. But you're only going to do a tier 2. Let's talk about that. Second of all, no, you set your minimum. So if you can start spending money, if you can start, investing capital at $1 million, the minute you raise $1 million is when you're going to start investing the capital. It's not, you don't have to wait till you raise $50 million.
Okay. That makes sense. And did you say something about 250,000?
Yeah, well, that's what, like, if you pull the statistics from Edgar, that's what the average is, but that's not what it costs here.
Okay.
Yeah.
So they're basically saying the SEC average that they're having on their Edgar website says it's going to cost $250,000 to get it registered and through the approval process and stuff like that.
Right.
Okay.
Right.
And what you're saying is that you basically are recommending $75,000. That would include some of the fees and getting you through that first year filings and auditing and all that kind of good stuff.
Exactly.
And what are some of the ongoing things that you have to do in a Regulation A? Is it mainly just the annual auditing and filings?
So you have to do an annual audit, a semi-annual financial report, and then every time you have like a big event happening, you have to file a simple report called a 1U, which is just a report that says, hey, like, for example, I showed you them, like, hey, we fired our auditor, or hey, we bought a property, that kind of thing.
Okay. All right. Well, that's all the questions that we have here. Thank you so much, Jillian, for joining us. You've been a great guest with us and answered a lot of additional questions, and really excited to continue to follow you and possibly get through going through the process here. So there actually is one more question. What's a rough average cost for PPM for going through your group? So if somebody wants to do a PPM, and I'm assuming it's either, well, is the filing cost and stuff, is it similar in price from a 506B as it is a C? It's just a different paperwork?
We're, like I said earlier on, we're agnostic to 506B and C, so I don't care whether you do a 506B or C, it's the same cost for us. We charge a flat fee. It depends on how much money you're raising. It's a scale for a variety of reasons. One is our insurance cost goes up the more money you go out to raise. And second, that's number one. And number two is usually the larger the raise, the more complicated the deal, right? So sure. That's kind of why we do it that way. For a $2 to $4 million deal like here that they're asking about, you're going to pay anywhere from $12,500 to $15,000. We tell you to set aside $1,000 to $3,000 for blue sky fees. We charge those out separately. It's just at cost. And the reason why we do that is because the blue sky fees from state to state are so varied. Like, for example, Florida is 0. There is no planning fee for Florida. Colorado's 75, but then you have like Texas and Pennsylvania, which are $500. So that's why we don't include those in our fee. And we just kind of give you a rough estimate of saving $1,000 to $3,000 to pay for those fees.
That makes sense. Well, thank you again, Jillian, so much. I really appreciate all of your knowledge as you provided on the webinar today, and looking forward to actually meeting you in a few weeks as we join down in Miami and get together. So I really do appreciate all your time.
No problem. I'll talk to you guys soon. Have a great rest of your day.
You too. Bye-bye.
Bye.